Hello, I welcome to UPSC Prelims Chaturya series of Shantha Lakshmi IAS Academy, where we will discuss the daily prelims MCQs from the Hindu, Indian Express and PIB. Let's get started. The first question. Consider the following statements with respect to the Article 31C. Article 31C was inserted in the Constitution by 42nd Constitutional Amendment Act 1976. No law which seeks to implement the socialistic directive principles specified in Article 39 Clause B and Clause C shall be void on ground of contravention of the fundamental rights conferred by Article 14, Article 19 or Article 31. No law containing a declaration for giving effect to such a policy which give effect to Article 39 Clause B and Clause C shall be questioned in any court on the ground that it does not give effect to such policy. How many of these statements given above are correct? Only one, only two, all three, none of the above. This was in news recently, the ongoing hearing in the Supreme Court to decide whether the government can acquire and redistribute private property. A 9-judge constitution bench led by Chief Justice of India D.Y. Chandrachud asked a question of radical constitutional consequence. Does Article 31C still exist? About Article 31C, Article 31C was introduced by the Constitution 25th Amendment Act 1971. The law was essentially framed to ring-fence an adverse court ruling in the bank nationalization case of 1970. Article 31C says no law giving effect to the policy of the state towards securing the principles specified in Clause B or Clause C of Article 39 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridge any of the rights conferred by Article 14, 19 or Article 31. And no law containing declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. In the Keshwananda Bharati case 1973, the Supreme Court declared the above second provision of Article 31C as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. In 1976, Parliament enacted the Constitution 42nd Constitutional Amendment Act, which expanded the protection under Article 31C to all or any of the principles laid down in Part 4 of the Constitution. As a result, every single directive principles was protected from challenges under Article 14, 9 and 19 of the Constitution. In 1980, in its judgment in Minerva Mills versus Union of India, the Supreme Court struck down clauses 4 and 5 of the amendment. The 5-judgment bench held that Parliament's power to amend the Constitution was limited. It could not be used to remove these limitations and grant itself unlimited and absolute powers of the amendment. However, this ruling birthed a conundrum that the apex court must now address by striking down a part of the 25th Amendment. Did the court strike down Article 31C as a whole, or did it restore the post-Keshwananda Bharati case position wherein Article 39 Clause B and Clause C remained protected? So the answer is only 2, because Article 31C was inserted in the Constitution by 25th Constitutional Amendment Act 1971, not 42nd Constitutional Amendment Act 1976. Moving to the next question. With reference to the eggshell skull rule, consider the following statements. It is a common law principle applied in criminal litigation. It states that all victims should be partially compensated for their losses due to pre-existing injury. Which of the statement given above is are correct? 1 only, 2 only, both 1 and 2, neither 1 or 2. Underlining that the state and central consumer courts incorrectly applied the eggshell skull legal principle, the Supreme Court restored the compensation of rupees 5 lakhs awarded by the District Consumer Forum in a medical negligence case. About eggshell skull rule, it is a common law principle applied in civil litigation. It states that all victims should be fully compensated for their losses, even in situation where the victim was more susceptible in injury due to predisposing condition or pre-existing injury. This rule ensures that a defendant cannot escape liability for exacerbating a pre-existing condition due to their negligence. The eggshell skull doctrine is named after a hypothetical situation where a person with a fragile skull akin to an eggshell suffers a head injury. If the victim's skull fractures more easily than the average person, the defendant is still fully liable for all resulting damages despite the victim's unusual vulnerability. Despite its name, the eggshell skull rule applies to all types of injuries, including physical, emotional, and psychological harm. The rule is applied for claiming an enhanced compensation for damage that is more than what could have been ordinarily anticipated to be caused by the defendant. The eggshell skull rule has consequently also been referred to as a thin skull rule in many of the cases. The origins of the eggshell skull rule are the most often traced back to an 1891 Wasberg versus Putney case in Wisconsin, US. So the answer is neither one nor two because it is a common law principle applied in civil litigation, not criminal litigation. It states that all victims should be fully compensated for their losses due to pre-existing injury, not partially. Moving to the next question. Consider the following statements about International Labour Organization. International Labour Organization is the only tripartite United Nations agency. It was established by the Treaty of London as an affiliated agency. India is not a founding member of the ILO. How many of the statements given above are correct? Only one, only two, all three, none of the above. The International Labour Organization latest report, Ensuring Safety and Healthy at Work in a Changing Climate, is an urgent call to ensure the future of labor is climate-proofed and to address the constantly evolving work environment as a planet warms. The UN body states that well over a third of the world's population are exposed to excessive heat annually, leading to almost 23 million work-related injuries. About ILO, the only tripartite UN agency since 1919, the ILO brings together governments, employers, and workers of 187 member states. They together settle labor standards, develop policies, and devise programs promoting decent work for all women and men. Established in 1919 by the Treaty of Versailles. After the demise of the League of Nations, the ILO became the first specialized agency associated with UN in 1946. Headquarters Geneva, Switzerland. Objectives: the main aim of the ILO are to promote rights at work, encourage decent employment opportunities, enhance social protection, and strengthen dialogue on work-related issues. Member countries, 187 member states. India is a founding member of the ILO. ILO functions through three main bodies. The International Labour Conference sets the international labor standards and the broad policies of the ILO. It meets annually in Geneva, often called an International Parliament of Labour. The governing body is the Executive Council of the ILO. It meets 3 times a year in Geneva. Lastly, the International Labour Office is the permanent secretariat of the ILO. It received the Nobel Peace Prize in 1969 for improving peace among classes, pursuing justice for workers, and for technical assistance to other developing nations. So the answer is only one, because it was established by the Treaty of Versailles, not the Treaty of London. India is a founding member of the ILO. Moving to the next question. Choose correct one with respect to the Booker Prize. The Booker Prize awards any novel originally written in English and published in the UK and Ireland. Irish author Paul Lynch wins the 2023 Booker Prize for his novel Prophet Song. Which of the statement given above is are correct? One only, two only, both one and two, neither one or two. This was in news recently. Booker slavery links behind the criticism of the prestigious literary prize. The Booker Prize, one of the most prestigious award in the literary world, has repeatedly come under fire for the historical links to slavery of its original sponsor Booker Group. Last week, a BBC radio post reminded the organization behind the prize that Booker Group founders George and Josiah Booker did not, as the prize website said, manage enslaved people rather than they turned African people into slaves. The website then changed the word managed to enslaved. Irish author Paul Lynch wins the 2023 Booker Prize for his novel Prophet Song. About this prize, the Booker Prize is the leading literary award in English-speaking world. The Booker Prize awards any novel originally written in English and published in the UK and Ireland in the year of the prize, regardless of nationality of their author. The novel must be an original work in English. It must be published by a registered UK or Irish imprint. Self-published novels are not eligible. Organizations involved in this Booker Prize were Man Group. A Man Group is an active investment management firm founded in 1783. It has sponsored the Man Booker Prize since 2002. And the Booker Prize Foundation, it is a registered charity established in 2002. Since then, it has been responsible for the award of the Man Booker Prize for Fiction and for the Man Booker International Prize since its inauguration in 2005. So the answer is both 1 and 2 are correct. Moving to the next question. Consider the following statements regarding the Goods and Services Tax. GST is a union subject according to the Constitution of India. It is an indirect tax that came into effect on July 1st, 2017 as a result of the 101st Amendment to the Constitution. For tax collection, it is divided into 5 tax slabs: 0%, 5%, 12%, 18%, and 28%. How many of the statements given above are correct? Only one, only two, all three, none of the above. April gross GST taking power past rupees 2.1 lakh crore in a new record. Year-end compliances lifted India's gross goods and services tax revenues past a record rupees 2.1 lakh crore in April, reflecting a 12.4% growth over the previous highest tally of rupees 1.87 lakh crore in the same month last year. About this tax, it is an indirect tax that came into effect on July 1st, 2017 as a result of the 101st Amendment Act to the Indian Constitution. It is imposed on both manufacturers and sellers of goods as well as suppliers of services. For tax collection, it is divided into 5 tax slabs: 0%, 5%, 12%, 18%, and 28%. GST is a concurrent subject governed by both center and the states. The GST bill was first introduced in 2014 as the 122nd Constitutional Amendment Bill. Article 279A, GST Council to be formed by the President to administer and govern the GST. Its chairman is Union Minister of India, with ministers nominated by the state governments as its members. So the answer is only 2 because GST is a concurrent subject according to the Constitution of India, not union subject. Thank you. This is the today's session.